Welcome back to the deep dive. Today, we are cracking open a legal puzzle that honestly feels like it was ripped straight out of a noir thriller.
It really does.
It's got everything: a dark farmhouse, a betrayal between cousins, a trunk full of bricks, and a hitman who isn't who he says he is. But the crazy thing is, this entire life or death drama hinges on something as mundane as grammar.
hmm
We're looking at a stack of sources focusing on the legal mechanics of conspiracy, specifically a concept called the feigned accomplice.
It's a fascinating topic because it forces us to stare directly into that gap between what you do and what you intend to do.
Yeah.
It asks a pretty fundamental question. Is a crime the harm you actually cause? Or is a crime the darkness you hold in your heart?
That is heavy. To get us centered, I want to start with a hook for you. A scenario that puts you right in the driver's seat. Imagine this. You decide you want your business rival taken out. You've crossed the line. You go to a seedy bar. You find a guy who looks tough leather jacket, scar, the whole nine yards. You slide an envelope with $5,000 across the psyche table. You hand him a photo. He nods, takes the cash, and says, "Consider it done."
A classic setup.
Right. You go home, terrified but satisfied. You wait for the news. But here's the twist. That guy in the bar, he was an undercover cop, or maybe just a scammer. He never intended to hurt anyone. He walked straight to the precinct to file a report on you. So the question is, have you committed a conspiracy?
That is the million-dollar question, isn't it?
Because in your head, you're a criminal mastermind. You paid the money. You had the intent. But in reality, you were just a person sitting in a bar talking to a wall. You were alone in your conspiracy. So are you guilty?
Mm.
To answer this, we need to dissect a landmark case from 1975, State v. St. Christopher. It's a Minnesota Supreme Court case involving a matricide plot, a plot to kill a mother, that hinges entirely on how the law defines the word agreement.
It's a perfect case study. Our mission today is to dissect the transition from the old way of thinking, what we call the bilateral theory, to the modern unilateral theory. And we're going to do this methodically. We really need to tear this apart to see how the gears turn.
I love it, but before we get to the case, we have to understand the world that existed before it. Let's start with the legal foundations. Before 1975, before this shift happened, what was the general rule regarding conspiracy and agreement?
The general rule was known as the bilateral theory. Now, bilateral is the key word there. Traditionally, conspiracy absolutely 100% required a meeting of the minds between two or more people.
Okay, meeting of the minds. That sounds like contract law. What does that actually look like when you're charging someone with a crime? What are the elements?
It essentially had three ironclad elements.
Right.
First, you needed an actual agreement between two or more persons. Second, there had to be a common object to commit an unlawful act. And third, and this is the kicker, there had to be specific intent by all members to achieve that object.
Okay, let's unpack that third one. Specific intent by all members. That sounds reasonable on the surface. You want everyone to be on the same page. But what happens if one person is lying? What if one person is my undercover cop from the bar?
And that's the mathematical flaw that makes the bilateral theory so fragile. If one party feigns agreement, if they're faking it, there is no true agreement. Mathematically, it's like multiplying by zero.
Multiplying by zero.
Exactly. If I have 100% criminal intent and you have 0% criminal intent because you're a cop, the equation becomes 100 times zero. The result is zero. The agreement collapses. So under the old common law, no conspiracy exists for anyone.
Wait, hold on. I need to make sure I'm hearing this right. Under the old rule, if I hire a hitman to kill my rival and I pay him and I give him the gun, if it turns out he was a good guy working for the police, I walk free.
On the conspiracy charge, yes, precisely. You walk free. This was the rule in previous Minnesota cases like State v. Burns. The court explicitly said you need a common object which each member intends to accomplish. Since the cop didn't intend to accomplish it, you can't conspire with him. You are legally just a person talking to yourself.
That feels completely broken. I mean, I'm just as dangerous whether the guy helps me or not. I tried to make it happen.
And that frustration you're feeling is exactly why the legal world started to shift. That loophole is what leads us directly to our case study, because someone actually tried to use that loophole to get away with plotting to kill his own mother.
Let's get into it. This is State v. St. Christopher. It's 1975. So let's analyze State v. St. Christopher. First, what are the legally dispositive facts?
Okay, so the defendant is a man named Daniel St. Christopher. Now, interestingly, this wasn't his birth name. He was formerly named Marlon Peter Olson, but legally changed his name to St. Christopher.
St. Christopher. Isn't that the patron saint of travelers? The protector.
The irony is rarely lost in criminal law.
Mm.
Yes. Now, Daniel St. Christopher had a brutal plan. He wanted to kill his mother. The motive was classic greed. He wanted to inherit $125,000 from his father, and his mother was in the way.
That's cold. But you can't do that alone. Who did he try to rope into this?
He recruited his own cousin, a man named Roger Zobel. And this wasn't just some vague, I wish he was gone conversation over beers. This is meticulous. The method was that Zobel was to go to the farmhouse on Saturday, March 23rd.
Okay, so we have a date.
It gets worse. St. Christopher told Zobel to break the mother's neck. Then he was to put her body in a trunk, weigh it down with bricks, which St. Christopher had already prepared, and throw it in the river.
Wow, he had the bricks ready? That's
Yeah.
hauntingly specific. It's not just a fantasy at that point. But here comes the twist we talked about. What about the cousin, Zobel? Was he on board with this nightmare?
No. And that's the twist. Zobel never intended to help. He played along because he was likely terrified or just wanted to get information. He went to the police on March 18th, days before the planned murder. The police told Zobel to cooperate, which in this context meant keep faking it.
So the police are essentially directing the play now. They're telling the cousin, nod your head, say yes, let him think it's happening. And did St. Christopher actually do anything on the day of, or was he just waiting by the phone?
He committed a significant overt act. On the day of the planned murder, St. Christopher feigned car trouble to lure his father away from the farmhouse, leaving his mother alone. Then he signaled Zobel to proceed with the killing. St. Christopher was arrested shortly after making that signal.
Okay, so let's freeze frame right there. We have a man who has done everything in his power to execute a murder. He's lured the father away. He's signaled the hitman. But the hitman is a snitch working for the cops. Under the old rules we just talked about, St. Christopher should walk, right?
That is exactly the argument his lawyers made.
And what was the core legal issue?
The issue is this. Can a defendant be convicted of conspiracy if the only person with whom he conspired never intended to participate, but merely feigned agreement?
It seems like the answer should be no, based on history. But the court did something different here. What rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements.
The court rejected the common law bilateral rule we discussed. Instead, they adopted the unilateral rule, largely based on the Model Penal Code Section 5.03. And the rule shifts the focus entirely.
Okay, what are its elements?
It has three distinct elements. First, culpable conduct. The defendant agrees with another person to commit a crime, but this is measured by the defendant's subjective belief. Second, unilateral intent. The defendant specifically intends to promote or facilitate the crime. And third, the irrelevance of the co-conspirator. The secret intent or feigned agreement of the other party is immaterial to the defendant's guilt.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element, the agreement culpable conduct?
Well, the defense argued that you can't agree with a liar. But the court looked at the unilateral approach, supported by legal scholars and the Model Penal Code. The sub-rule here is that agreement is defined entirely from the defendant's viewpoint.
So it doesn't matter what Zobel was thinking.
Not for St. Christopher's guilt. The analysis showed that St. Christopher believed he had an agreement. I mean, look at the facts. He plotted the details, the bricks, the river, the neck breaking. As the court noted, he had a guilty mind. He had done everything in his power to plot the commission of the crime. Therefore, the conclusion for this element was that it was met. Zobel's secret intent did not negate St. Christopher's conduct.
Understood. Now, what about the second element, statutory construction? How did the court justify this shift based on the statute's text?
This is my favorite part of the case because it all comes down to grammar. The issue was whether the Minnesota statute actually supported this new unilateral reading. And you have to look at the words. The old statute said, when two or more persons shall conspire.
Two or more persons? That implies a relationship. It implies the bilateral requirement. You need two to tango.
Correct. But the legislature had updated the law. The new statute, Minnesota St. 609.175, didn't use that phrase as the subject. It said, whoever conspires with another.
Whoever.
Singular.
That is subtle.
It's subtle, but it's dispositive. The court analyzed this singular phrasing, whoever, and concluded that it authorizes a unilateral conviction. By saying whoever, the law focuses on the individual actor, not the pair. It aligns Minnesota with the Model Penal Code's approach. So the conclusion was that this element was met. The statute absolutely allowed for this.
It is amazing how much weight the word whoever is carrying there. It changes the subject from the group to the person. So after analyzing all the elements, what was the court's final conclusion?
The holding was affirmed. The trial court was free to convict St. Christopher of conspiracy despite Zobel's feigned agreement. The factual impossibility of the conspiracy, because Zoval was an informant, is not a defense under the unilateral approach. St. Christopher stays in prison.
That statutory shift is subtle but deadly. And frankly, it makes a lot more sense if we're trying to lock up dangerous people. But to make sure this distinction between bilateral and unilateral is unforgettable for everyone listening, I want to run a visceral hypothetical.
Let's do it. Test the rule.
Okay, imagine the Cannibal Club.
Oh boy. Here we go.
Stay with me. I want to start a club where we agree to kidnap a victim and eat them. I go onto a dark web forum. I find you. We agree to meet in a soundproof basement. It smells like bleach. I show you my butcher knives. I show you a boiling pot of water that is already bubbling, and I say, "Are you in?" You look at the knives, you look at me, and you say, "I'm in. Let's eat."
Truly a horrific scenario.
Right. Now, scenario A, you are a fellow cannibal. You are just as sick as I am. We shake hands. In that case, we are clearly both going to jail.
Correct. That's a conspiracy under any definition.
But let's look at scenario B. You are actually an undercover FBI agent. You are repulsed by me. You are trying not to throw up, but you nod and say, "Let's eat," just to get me on tape. Under the bilateral rule, the old law, am I guilty in scenario B?
The bilateral answer is no. You are free to go.
That is hearing it in that context with the boiling pot, it's shocking.
It is. In scenario B, under the old rule, there is no meeting of minds to eat human flesh because I, the FBI agent, never actually agreed to it. I was faking. Since I am not conspiring, you cannot conspire with me. You're a danger, certainly. You have a pot and a knife. But legally, under the old bilateral rules, you are just a lone lunatic. You can't be charged with conspiracy.
And under the unilateral rule, the rule from St. Christopher.
The unilateral answer is guilty. Absolutely guilty. You formulated the plan. You believed you had a partner. Your culpability is established by your own intent to boil a victim. The fact that I'm an FBI agent saves the victim, but it seals your doom as a conspirator. The law punishes your firm purpose to commit the crime.
That distinction is a classic law school trap. Synthesize the rules we've discussed into a diagnostic checklist for the listener to use if they encounter a conspiracy issue.
Absolutely. Here is the diagnostic checklist for conspiracy analysis. Step 1. Check the statute's subject. Look closely at the wording. Does it say, when two or more persons agree?
Right.
If so, you apply the bilateral theory. But if it says whoever agrees with another,
Yep.
you apply the unilateral theory.
Okay, check the subject. Two or more versus whoever. Step 2.
Step 2. Check the co-conspirator's mind. Ask yourself, is the partner a police officer, an informant, or a faker? If the answer is yes, you have a fork in the road.
Yep.
Under bilateral, no conspiracy. Acquit. Under unilateral, yes, conspiracy, convict.
Simple enough. And the final step.
Step 3. Check the defendant's belief. Did the defendant believe there was an agreement? Did the defendant intend to promote the crime? If yes, then under the model penal code approach, culpability is established. It doesn't matter what was in the other guy's head, it matters what was in the defendant's head.
This has been a fascinating look at how the law tightened the net on criminal intent. What stands out to me is that one word in a statute, whoever versus two or more, can be the difference between a 20-year sentence and walking free. It really shows the power of language.
It really does. And if we connect this to the bigger picture, it raises a provocative question about what we are actually punishing. The court mentioned that under the unilateral code, you are punished for your intent and your firm purpose, even if the crime was factually impossible.
That's the part that sticks with me. St. Christopher couldn't have killed his mother with Zobel because Zobel was never going to do it. The crime was impossible from the start.
Exactly. So does this mean the law is punishing you for your evil thoughts? Or is it punishing you for the danger you tried to create? St. Christopher didn't know it was impossible. The law decided that his ignorance was no excuse for his malice. We used to demand that a conspiracy be a group danger. Now we accept that the danger can exist entirely within one person's mind, provided they think they aren't alone.
Are we punishing the act or are we punishing the soul? That is a question we will leave you to mull over. Thanks for listening to this deep dive into the dark side of grammar.
Until next time.